Any mention?
May I please, Your Lordship, I beg to mention item number 18, Lordship.
Number?
18, Lordship. I already informed to private respondent also.
No objection, Your Lordship.
Anjan Marak.
Yes, Lordship.
Why?
Conducting counsel is out of state, Lordship.
No objection.
Yes, 2 weeks.
Highly Honourable Lordship.
May I please, Your Lordship, I beg to mention item number 16.
Not for the petitioner. System.
No objection, Your Lordship.
No objection. Okay, yes.
Similar prayer to item number 19, Your Lordship.
What happened to Mr. Depp and Day?
Mr. Day, he is out of station. Mr. Depp is not keeping well.
So then you take the chance and do the hearing.
So they have been instructed to take an adjournment.
19.
19th already gone for mediation, in fact.
Yeah.
You don't need to mention it. Yes. Okay. Yes. Yes.
Your Lordship, I beg to mention item 11 and 12. Your Lordship, here we're still awaiting instructions from the department.
Lordship, I am for the petitioner. Lordship. I have no objection, Lordship.
What's the matter about?
This matter is regarding deduction of monthly salary, Lordship.
From the school teachers?
Yes,
Yes,
Lordship.
Your Lordship.
There's been stopped recovery?
Yes,
The
Lordship.
deduction has been stopped, Your Lordship.
Yes. When?
After 2 weeks, Your Lordship.
Yes, so 2 weeks variable. The county to obtain specific instructions. Yes.
Obliged.
The Reno County is a place for once allowed for a 2 week to obtain this. Yes.
Obliged, Your
Yes.
Lordship.
Supplementary list item number 1.
Please, my lord. My lord, I appear in items 1, 2, and 3.
One?
They are connected matters.
1, 2, and?
Items 1, 2,
Yes.
Billy,
Okay.
and Adali.
Yes.
My lord, I do apologize for not being physically present.
There's no issue. Yes. What is the matter about?
My lord, this matter has actually seen many rounds, and this matter has also been before your lordship. Lordship, to start with, at the outset, I just wanted to say that this is not adversarial. The two pertinent facts are that these two ladies and a gentleman, admittedly, there is no dispute that the land has been acquired. And admittedly, again, there is no dispute that they haven't got 1 paisa of compensation money.
Acquired for?
This was acquired as part of the Oberoi Airport extension.
Okay, yes.
And Lordship, land was acquired in 2 tranches. One was a bigger tranche of almost 192 acres. The second was a smaller tranche of 32 acres. The 32 acres one, your lordship is aware, had gone up to the Supreme Court and an inquiry was done in that matter. We don't belong to that tranche. We belong to the first tranche, the 192 acres.
When was this 192 acres acquired or taken possession?
As long back as 2011 to 2012. But we have been before your lordships. If I may show lordship just 2 documents.
Yes.
One is at page 48. Dated
48.
11th October, page number 48.
Yes.
Dated 48 and 49 is the type copy, lordship.
Yes.
This is dated 11th October 2012. This is the first of this lordship. And lordship will see my name at serial number 2. Serial number 14. Dilip Mangru.
But this is Visa Loan Lalu?
Yes, lordship, that's at serial number 17. Those 3 serve together, lordship. 17 is Visa Loan Lalu. 2 is Dilip Mangru. 14 is Ardaleen Khawal. That is
Okay.
item 1 to 3. Their Lordship will have page number 64 and 65.
Yes.
Lordship will see that this is at 65. This is the list of awardees actually. New rate as per the right to fair compensation, transference, land acquisition, landowners and homicide staff of the acquisition rate. Here again I figure Lordship. First name is Billy Twangu.
Okay. Yeah, okay, we see it, we get it, yes.
Yes. So Lordship, the process is going on. Next Lordship will have page 87.
Okay, you say what happened now. I mean, you mean to say that you have not even got 1 paisa?
Lord, I have not got 1 paisa, Lordship.
Yes, Mr. Let them get instructions.
Allow me some time to obtain instructions, will it?
Yes.
If I may just add one thing, Lordship. There was a misstep from my side, I must really admit. Because when the tranche related to the 32 acres was before the Supreme Court, I filed an impediment before the Supreme Court.
Oh.
I was not advised properly, but that impediment was not allowed. But as a result, Lordship, my matter got mixed up with that 32 tranches. The matter was then tagged.
No, what's happened to that, 1 second, what's happened to that division bench matter?
My lord, that one the division bench has directed the special judicial officer.
Still pending?
My lord, it disposed of.
It
was disposed of, allowing the parties to file a regular appeal under the Land Acquisition Act. So
this was treated as a reference. So that reference has been disposed of.
But I'm not part of that also, Lordship. I've fallen through the cracks. That is my problem.
Fallen through the cracks, but after that, okay. So after your impediment was disallowed, did you pursue the matter thereafter? When was the impediment disallowed? When was it disallowed?
Second August 2017. In fact, I came back to the High Court.
17 was disallowed. Then what steps did you take thereafter?
Lordship, in fact, there's another order of 29/11/2017.
Let us see that.
95. Yes, Lordship. 95 and 96.
It's not that you've, anyway, yes, 95.
95 and 96. That bottom of the page, Lordship, that's upon taking up the matter involved in such and such list, we find the position moreover intriguing, rather shocking. Learned counsel, so and so appearing for the applicants in the first place, submitted that we may be allowed to withdraw. Having regard to the circumstances of the case, we declined this prayer. Thereafter, Shri S.A. pointed out that these 3 applicants were the petitioners in the respective petitions, which were decided by one of us, S.R. Senjay, sitting singly on 4/5/2017, and these applicants had in fact filed an interlocutory application before the Honorable Supreme Court, but this fact was never divulged to him. Learned Additional Senior GA, K. Khan, attempted to submit that as per his instructions, the Deputy Commissioner has taken steps for compliance of the order so passed on 4/5/2017. We find such an approach on the part of the DCP seriously questionable because prima facie the order passed by a single judge of this court on 4/5/2017 in these matters stands overwritten by the order dated 2/8/2017 as passed by the Honorable Supreme Court. It is left to anybody's guess as to how the Deputy Commissioner was at all attempting to carry out compliance with the order of the single judge of this court in the face of the different nature directions by the Honorable Supreme Court. So, Lordship, that matter got entangled with the second 8 order. And finally, there is an order at page 102. At page 102, Lordship. Short treatment of the petitioner as projected by the Learned Counsel is that in terms of the order dated 4/8/2017, the Deputy Commissioner Nomco was to settle the claims of the petitioner, which till date has not been done. Hence, the instant application for compliance with the directions dated 4/8/2017. DC Nomco is to ensure compliance of the directions dated 4/8/2017, strictly in accordance with law and consistent with directions of this court issued from time to time, needful to be done preferably within 2 months. Then again, Lordship, this was not done. And at page 105 is an order where Lordship is also part of the bench, Lordship will have 806, which is the offensive part. If we allow the above step, it will be in the nature of revisiting the original order dated 4/2017, whereby writ petition has been disposed of. This is impermissible. As such, the miscellaneous application is liable to be dismissed and stands accordingly dismissed. So, Lordship, this was on de-tagging. To dictate my problem is that I don't know what is the bar in giving either. Either it is because my records are not available.
So you file an SLP against this order also?
Yes, Lordship. And on de-tagging, Lordship, the courts have said that no, you wait your turn. So now that process is done, Lordship, the de-tagging has not been done, so I have not been considered.
Okay, we should notice, yes. But you have MS, sir. S. Alam. Right?
Yes, Lordship. Yes.
Who's assisting you?
Lordship.
S. Marpana. Yes. You should notice Mr. S. Sen is present, except on behalf of
1 and 2.
What about where's Dr. Muzika? Yes, Dr. Muzika, DSGI is present, except on behalf of number 3. No further notice required. Just the matter for 2 weeks for instructions or affidavit. Yes.
And wait, Lordship, if they could also just clarify whether they're not able to assess.
No, let them come by instructions after 2 weeks. Yes, we'll see. Yes.
Item number 4.
You're right, it become a totally mixed up matter in the sense that, it's already disposed of division benches. Yes.
Item number 4.
Yes.
Yes, my lord.
There was a slight problem here. Did you serve notice upon them?
Yes, my lord, we did.
I'm a payment.
So, my lord, we'll be filing the affidavit for it. So, my lord, we have the copies of the meeting that was held
on. It's not recorded here in the order to take this order along with copies of the petition. It's skipped. I don't know how.
But I have the instructions, my lord. I'll place all the instructions.
What happened?
Yes, my lord, it was held against me. In the meeting, it was held against me. Do you need a copy, sir?
But here, what happened, my lord? There are rules, my lord. It's called Ceylon Sports Association Football Tournament Rules.
Yeah.
Rule 24 says, my lord, any club fielding an ineligible players or players by impersonation in a match will be sanctioned with a forfeit and considered to have lost the match by 0-3 goals.
Yes.
Even if they win, actually, my lord.
We understand that, yes.
The ineligible players shall stand suspended for a period of 1 year from the date of occurrence.
And bylaw 16 says you have to protest within 1 hour.
Yes, my lord.
You didn't protest within 1 hour?
I protest within 1 hour, my lord. But
here, what is important, my lord? I'll just read, my lord. Bylaw 16 says, protest in any should be lodged and written within 1 hour after the conclusion of the match, accompanied with a protest fee of rupees 2,500 only, which is non-refundable. Protest on known fact shall not be entertained when the result of the match has been decided. But unknown facts, there is a window of 1 hour, my lord. But known fact, there is no window. Known fact has to be then and there, on the spot. It has to be reported, my lord. Here, what happened, my lord? 18/7/25 was the first match, my lord. Was the match which they have referred to. But in that match, that was the match between. I'll just refer to this, my notes, my lord. First match was between Limukra Sports Club and Golf Links Sports Club. Actual result was that they won by 4-0, my lord, in that match. But during the currency of the match, my lord, protest was raised with the referee by Golf Link Sports Club.
By?
Golf Link. They are playing against Golf Link at that time. During the match, protest was registered with the referee that there are ineligible players playing in the match, my lord. And that's why the cognizance was taken of that protest, and the protest was accepted, and they are declared to have lost
the match. Was allowed to carry on and it got over.
My lord. Second match against which they have come, my lord. Here what happened? Well, if I may just refer, the match was a draw, my lord, 1-1. The second match for which they are aggrieved. Match kicked off at 1:15 p.m. my lord. And match ended. There's a 40 minutes first half, 10 minutes break, 40 minutes second half, and 7 minutes extra time. 97 minutes. Match got over at 2:52 p.m. my lord. They registered the protest at 3:30 p.m. I'll just take your lordship because they didn't annex the complete documents. I'll just point it out, my lord.
Let them file affidavit then.
Yes, my lord. And also, my lord, I need to take
There are
instructions.
two aspects, my lord. In the last match, if I may just refer to this, my lord.
Yes.
The matter has become fait accompli, my lord. Because
What is the impact? What is the impact on the current tournament?
My lord, that's what I'm
Over
submitting.
now.
So, yes, my lord, so I
My
could
lord,
not play.
As the tournament over, is still
My lord, in
complete.
this match, Light Lulong won the match. They proceeded to quarterfinal. They lost in the quarterfinal. They played Lapalang in the quarterfinal, and Lapalang is gone up, my lord.
So-
to the semi-final. The matter now, it is fait accompli in my humble submission, my lord. Everything cannot be reversed.
So I lost because, my lord,
That's
my
one
scores
aspect,
were
my lord.
taken away from me.
Please, yes.
Yes, my lord.
So as I was submitting, my lord, they lost the match. Light Lulong club won the match, my lord. They proceeded to quarterfinal.
So what is the ground for suspension? Because they're not registered with the club, or
Yes, ma'am.
the three players.
We had,
Why were they suspended?
Well, kindly,
The transfer was not done properly.
my lord, I had one ineligible player. That is the reason.
He's from where?
well,
so I'll-
flag G, my lord, so kindly refers me.
Yes.
On the reverse page, lots of
Because with matters like this, it's always better that there's an amicable solution by the association also. Because there have been matters also before AFF in which I, as a lawyer, appeared in Goa also. You remember? I mean,
Yes, my lord.
People who know remember also.
You've told me.
Lajong, we had a problem with regard to same ineligibility of, these players.
So, my lord, flag G, lots of kindly say this is the protest submitted by them, my lord.
When they submitted, what's the time?
Is
3:30 p.m.
The match got over what time?
Match got over at 2:52 p.m. my lord.
So it's within 1 hour.
Yes, within 1 hour.
But it was a known fact. We are saying that it was a known fact known to them.
Now you file your affidavit and then
Yes,
you
my
will
lord.
pass. The
I'll
thing is
seek
that at least
instructions.
on record you should go as what happened. Yes,
Otherwise, also
Dr. Mosika.
in this kind of matter, my lord, writ petition, writ jurisdiction.
It's not maintainable. Only that because
Right.
as per what was projected on that day, there's a glaring arbitrariness. That if you apply one standard in another game, whereby the three ineligible players, complaint was lodged and deducted the points, and that other match,
The clear distinction. My lord.
in spite of suspending the player and allowing the other team to keep the points, that is
Well, there are clear distinctions.
that is why this court had
known facts
passed
and
the
unknown
order.
facts, my lord.
You file that and we'll close it.
My lord, we'll file.
Yes.
We did know, my lord. That is the only thing.
Doesn't matter. You also should know the rules.
Yes,
so
my
if you
lord.
play in a certain tournament, then you must be well versed, whether the manager or something, with exactly what is the procedure in such instances. Yes, or you want to withdraw it?
No, my lord. So I don't have instructions because I received this.
Yes, Dr. Mosika has entered appearance today on behalf of all the respondents.
Yes, ma'am.
So, my
One
lord,
and two.
my lord, may I also...
No further notice is called upon respondents. It is submitted by learned senior counsel that the action taken by the respondents was as per the bylaws of the Shillong Sports Association governing such tournaments. In this regard, the learned senior counsel has placed extract of bylaw number 16, 24 and 28 been produced by the court, which has led to such action. So, in this view, the matter as the respondent to bring these materials on record with affidavit just after.
And madam, there was a direction on the last occasion to dispose of the representatives, and we have done that.
Yes, yes. So at the outset, it is submitted that as per directions of this court, by order dated
I'll tell you, my lord.
29/7.
25.
The representation has since been disposed with, and the findings have been placed for this
Flag
court.
H, my lord.
Yes.
The last flag.
This court, yes. I thought, yes. After 2 weeks.
Yes, my lord.
Yes.
That's all.
Item number 5.
Who's appearing for AG?
My lord. AG, Mr. Harmokran.
Where is he today?
He has filed an affidavit.
You see, Mr. Sen, you're on a very sticky wicket, sorry. Because apart from the first part in representation with regard to 2013, which you did not divulge in a petition. The second bearing fact, even Mr. Shulai, why didn't you bring notice of the court that is already opted for the second option?
Lordship, I'm sorry.
I have stated in my petition.
I'm sorry, Your
That you
Lordship.
opted for the second option.
I have been coerced. No, my lord, that I have been
dismissing your application.
No,
Lordship, I'm sorry, Your Lordship.
It's replete with suppression, and even that.
How is suppression, my lord? I just make it. I have made a statement, my lord.
He never submitted that that the option.
My lord,
he has opted option 2.
I have made categorical, my lord, that I have been coerced.
A question of coercion.
10. Lordship will come to 10. Paragraph 10. Of the writ petition. The writ petitioner states that the aforesaid action of the past alien authority has been virtually forced to revert back to the state's pale with pay protection, with prayer protection last drawn 10, my lord. Page 14.
Read 10. Can you read 10?
10, my lord. Paragraph 10, page 14.
Virtually forced to revert back to state's care. Okay?
Yes, my lord. It's a question. Lordship will see the action. They have given me an option that
you're not coerced.
But that is not forcing. What else, man?
What is an option?
Option has been given. Either you remain in if I can finish. Either you remain in a SCT pay scale.
You just where's the advocate? Where's the attorney general? Accountant general. Let's see the affidavit file.
Lordship.
When did you take the option?
My lord.
When did you take the option? We go to the affidavit. We are closing the judgment.
24.
Firstly, we're prepared to overlook the fact that you suppress the fact.
No, I have not suppressed. My humble submission, I have not suppressed. Lordship will have to come to a finding I have suppressed.
Suppression of
I have not. Lordship cannot just say I have suppressed.
We'll come to finding regarding your suppression of your presentation. We'll come to finding. Yes.
Lordship, what is that? Now, what suppression he is saying? I filed a representation 2013. Now, representation is this, my consideration.
You can't twist the fact or shape. Please listen, Mr. Sen. Please, do not try to argue with the court.
Lordship.
You're a counsel, you're a seasoned counsel.
Lordship.
So please the fact of your case. It is not your personal case.
Lordship.
Remember.
Lordship.
You understand, you don't have to wear it on your sleeve.
Man.
What have you projected on that day? You have projected that
Lordship.
option was given.
Lordship.
The only consideration is that 5%, what do you call it, that relaxation is given to shell trap candidates. Okay, court accepted your accepted submission. Now it's submitted that 2013, by which you've been given senior grade, that was never acted upon, you say. But then in your representation, you say that was never acted upon, and so and then you challenge supersession of that 2013 again.
No, my lord. So here some
supersession and then the option.
No.
Now it comes that you have not stated that you've been coerced. She said you are virtually coercing him to accept the second option. And see the affidavit of the AG. Where's Mr. Harmuplang?
Lordship, give me 2 minutes, my lord, on the first part. On the first part, my lord, if I can, Lordship, make it 2013.
Yes, take out your affidavit.
Give me your affidavit.
Give me your affidavit.
Where is son?
Where's it? Where's the affidavit?
My affidavit.
No, Attorney General's. Because they were not there, so I'll just go into the affidavit, and it says here.
You don't even have the file with you.
From 9. See, you were given option. You have come to court straight away.
I have come straight away, my lord. 24 days.
Number 9, 9 of the AG's affidavit.
Yes, my lord. I'm just reading it. With regard to the answering respondents, as per the government letter dated such and such, and in supposition of the notification dated 13, the petitioner was allowed to exercise his option in writing within 30 days to continue the AICT scale with no further increment. Two options were here: no further increment, or to continue HC scale, no further increment, or CS promotion. B, to revert back to the state's pay scale with a protection to the last pay drawn with the AICT pay scale, such and promotion applicable to such and such. Now, my lord.
Now see the last paragraph. And based on previous option, next paragraph
based on this pay scale, or the petitioner by
the previous option, pay slip was issued effect 2024 in a state scale level 15 by e-slips also.
So, my lord, I was given an option, virtually I was forced, that you remain in AICT pay scale. That is my case. you will not get any increment, you will not get CA. Under rules, I am eligible for that, entitled for that, my lord. So I made a categorical statement. I was coerced into the state pay scale. Immediately I filed a representation that this is wrong. I qualify the norms. So, my lord, there is no suppression. Now, my lord, coming to the other thing, my lord, that 2013, now what I wrote in the representation collectively, 10 of them, my lord, the beneficiaries.
Then we were prepared to overlook that also.
My lord.
We are prepared to overlook even the fact that you did not mention in your petition, we overlooked that also. We dictated the order, we overlooked it.
My lord.
That, that's fine. Whatever it is, even though he discredits that 2013 notification, he is superseded, but an option, we are looking at option only on the ground that 5% relaxation, interpreting that clause, that whether it will be only appointments or promotions also. So we were on that part. But when we saw the affidavit saying that you already opted for that, then what remains to be decided?
I force, my lord. It's not that I have suppressed. I have categorically stated in my writ petition.
You don't have the file with you? Yes, we'll pass judgment. Yes.
Lordship, if Lordship, regarding suppression of facts, Lordship, may I please sub judgment, your Lordship?
Judgment?
Lordship.
Okay, we'll fix it for the hearing on next week, after 1 week.
In that case, my lord, it should have a bearing. If a fact doesn't have a bearing on the issue to be decided, my humble submission.
Let him air his yes.
Item number 6.
Obligement.
Tentatively, that's what the court has expressed. We've prepared to overlook that aspect also. If substantial injustice has been done, that's all. But then if that also has not come forward, that you already opted, yes.
Oblige, your Lordship.
Wrongly listed.
I think this has been placed before the mediation.
I mentioned this matter yesterday.
Why?
There is no scope for mediation. This is a nice decision.
It's all right, my lord.
Yes, Dr. N. Mozika today submits that due to.
There is no scope for mediation.
No, why was it allowed? Why did you agree on the last date?
I didn't exactly agree with it. This state was
Submits that he didn't exactly agree to mediation. No, we can't record that. Mr. Dr. Mozika submits that on closer examination of the matter, it appears that mediation would not be possible in this matter. Mr. Shongwan does not object to the same. According to the matter, list the matter on the next.
After 2 weeks, your Lordship.
Pleadings here, my lord.
Already the date already fixed.
No, pleadings here is complete, my lord. We will not file any rejoinder to the affidavit of state. It may be posted for hearing after 3 weeks.
Oblige, your Lordship.
So there's already a date.
Yes. Oblige, your Lordship.
Reading is item number 1.
Yes, where's the affidavit?
We have received instruction. 1 week's time we will file. We've taken some extra time. A week's time we will file.
Unless the council please won't allow 1 week's further time to file objection affidavit.
Item number 2.
Please, Your Lordships, the matter is listed for cross-examination today.
At 2 o'clock.
Yes, may I please, Your Lordship, I have filed adjournment on the ground that we are unable to contact the witness and Mr. Estep also is not keeping well.
Who's the witness today?
Your Lordships, the petitioner.
How many witnesses are there?
There are
today?
3 witnesses.
No,
And
are they all today?
No, Your Honor, we are unable to contact them, Your Honor.
That means you have your first witness, John Marak.
yes, Your Lordships, he is the petitioner.
Sri Iraq Marak, second, and Srimati
Raji, N. Raji.
And Raji.
Raji is your colleague.
Yes, my colleague.
You
Because she was there when we have filed the petition, she was there.
then
We have waited with.
Your Lordships, on the earlier occasion when I was not physically present here, Your Lordships had imposed cost of 3,000. So Your Lordships, in fact, on the last occasion also, they were insisting on for the early date as early possible, Your Lordships.
Are you interested in the matter, or you just?
We are interested, Your Lordship, but
Then not
only for today
witness
with
not coming on the date fixed.
Mr.
shows that
Esdev also is not
you're not
keeping
interested
well.
in the matter.
Mr. Esdev also is not keeping well today. He used to
They only
leave the
for
matter,
examination. It's not for anything else.
but the witness is not present, Your Lordship. I humbly apologize. Let this matter come after 2 weeks, Your Lordship, but positively will bring the.
What do you mean unable to contact the witness?
That's how I've been
It's
instructed.
missing.
Yeah.
You file FIR, missing
No.
persons. No.
So
Then?
we are not unable to contact him.
The matter is fixed today for examination of the of 3 witnesses, that is election petitioner and 2 others, stopped. However, an application adjournment petition has been filed by the counsel for the election petitioner, stating that they have been unable to contact the witnesses, and also the conducting counsel petitioner is indisposed. The parallel counsel for the respondent has vehemently objected to the prayer for adjournment. However, we have no choice. However, in the interest of justice, when you take a date,
28th of August, if your lordships, if that is fine.
Okay.
let the matter post the matter on 28th of August 2025. It is made clear that on the next date, should no witnesses appear, the election will be liable to pay cost, which is to be to the tune of how much? 10,000.
No, Lordship.
Then, before which is to be determined on the next date. Yes.
Deeply obliged, Lords.
Item number 3.
My lord, a report has been filed yesterday, my lord.
Still, how many cases pending?
However, my lord, in this most recent report, we have 3 districts in which these cases are pending. In respect
2 districts we know?
Yes, my lord. In respect of Jowai, my lord, West Jaintia Hills, we have not received instruction from the PP. But then, my lord, if lordship will have the earlier report, there we have mentioned that there are only 2 witnesses remains who has to be examined. And due to ill health, and they are from Assam, my lord, so there is a delay in that particular case. So, my lord, in respect of the recent report which I filed yesterday, my lord, the only difficulty is, my lord, in context of East Khasi Hills, my lord, one case, there's a stay, there's an appeal pending before the Court 1, my lord. And in respect of Garo Hills, my lord, both 2 cases are there, which are also stays operating, my lord.
Okay, now,
my lord, the only development which I can see is only in page number 3, my lord. There is case number 3 in East Khasi Hills, my lord. Only one, my lord, yes.
Now 35 witnesses, 15 examined.
Yes, in the earlier, my lord, report 14 21 witness remain, my lord. Now 20. So apparently, my lord, one has.
What about this other one at page 2?
My lord, page 2, it seems the case is still proceeding. It has not reached the evidence stage, my lord. Consideration of charge, because, my lord, there was a delay as per the CIS, and there was non-appearance of the accused, my lord, for a very long time. Notice were being issued time to time. So there probably, my lord, because of that, there was a huge delay.
And the third case is a stay.
My lord, yes. In the third case, that is page 4, my lord, there is a stay, my lord.
And from Garo Hills?
Garo Hills, my lord, we have 2 cases in which, my lord, they have already approached the Honorable High Court, my lord. The case are pending for quashing of fire.
Lord, stay is there, my lord, in the West Garo Hills district also, and the other.
Which one?
In phase 4, my lord. That phase 4 is also stays.
Stays there.
Stays there, my lord, and in these matters also, if I'm not wrong, my lord, there is a stay in these matters.
In both the matters of Garo Hills.
Yes, my lord.
You're not wrong, or it's accurate information?
Yes, my lord. They have approached the Honorable High Court. Matter is pending, my lord. What I see is at the bottom of page 6, my lord.
Appeal pending only.
Appeal.
Petition.
It's basically challenging the prosecution. That is my knowledge, my lord. That is challenging the local.
Yes, a status report dated 31st July 2025 has been filed. Approval of the same indicates that the situation remains the same from the last date, as much as 5 cases are still pending, 3 in East Khasi Hills and 2 in West Garo Hills. Tribunal Advocate General submits that with regard to one of the cases in East Khasi Hills, the same has not proceeded due to interim orders which has stayed the proceedings. With regard to the other 2 cases, it is seen that the same are proceeding and the same are still it will take a long time to dispose them. Anyway, are still pending, yes.
Still pending.
With regard and further, with regard to cases from West Garden Hills, it's reported that appeals challenging or proceedings challenging the appeals challenging. This is what kind of revision have they filed?
Challenging the.
And this is not indicated here in this.
Yes, my lord. It's not. I will place the relevant material before your lordship.
With regard to the case of West Garville's, the submits that the matters challenging the proceedings that pending for this court, he prays we are allowed to place. He prays allowed to place the exact details on the next date stuff. Further, it is submitted that there is no report from the loan case.
Yes, my lord.
That's pending in West Jayante Hill stuff. Stomach for list this matter after 1 month yes, for fresh status report.
Item number 4.
Please come over. May it please his lordship. Lordship, what happened on the basis of the inquiry report, Lordship, notice has been issued to the managing committee, Lordship. The managing committee has filed the show cause, Lordship. So we have decided to constitute a special committee to examine certain aspects. Lordship, if Lordship can have that letter dated 28 July. I'm sorry, Your Lordship, it could not be. We could not type it, Your Lordship. If I may read, Your Lordship.
What's the case about?
This is.
Lord, we had filed a writ, my lord, seeking some inquiry into an alleged my lord, malpractices that was happening in a particular school by the managing committee, my lord. Since numerous representation and complaints were filed, there was no action. So we approached this honorable court. My lord, in the meantime, my lord, they instituted magisterial inquiry, my lord, where the managing committee has been indicted. Now, my lord, pursuant to that, there was some follow-up action that was supposed to come from them that has not come. So, my lord, I think perhaps this is one of the actions they propose to take.
Then we close on the next date.
Lord,
since your plea has answered,
no, my lord, no action till now. Even though, my lord, there's a report indicting the managing committee, my lord, there's no action.
Place interim committee.
But I'm not privy to it. They have not supplied us any copy, my lord. And I don't know how long.
We have already.
Member of the committee.
No, my lord. I don't know the constitution of that committee also, my lord.
Where's the order for constitution?
Lordship.
The order is the first page.
That is in the first page, Your Lordship. May I read it, Your Lordship? Taking into consideration the finding, recommendation, and the opinion contained in the inquiry report submitted by the Deputy Commissioner, West Garo Hill District, Tura, as per the submitted inquiry.
Just the last part, I can't read other letters here.
Lordship, yes. Lordship, then a special committee is hereby constituted to conduct an independent inquiry on the following terms of reference: to conduct a thorough scrutiny of the financial records through account of the school for the past 10 years. To examine the proceeding book of the school managing committee for the last 3 years, to assess the legality of the agreement dated August 22, Your Lordship.
Yes.
So this will, Lordship, once this committee submits the report, then Lordship, the matter will be over.
But that is, that means the inquiry is not over also.
Lordship, so far the inquiry conducted by the Deputy Commissioner, that is over, Your Lordship.
Yes.
That is over.
Any instructions? Has inquiries commenced? You're for managing committee, correct? Oh, who for? Oh, you're for managing committee.
So far as the report, supplied as a copy, but so far as the documents have been filed by us, there are no instructions.
Lordship, yes.
This matter can be closed and
Lordship, in item 4, Your Lordship, that is Jumirul Islam. If Lordship kindly have item 4, Your Lordship, kindly have Lordship kindly have page 13, Your Lordship. That is the relief claim in the writ petition.
Court still trying to understand at what stage is your inquiry.
So far, the inquiry conducted by the deputy.
Now there was a magisterial inquiry report. Okay.
Yes, Your
against the
Lordship.
existing school managing committee of
Lordship, yes.
Rajabala.
Lordship, yes.
Now that is done.
Yes, Your Lordship.
Then this is the inquiry report even next
What
year.
happened, Your Lordship?
This is a magisterial inquiry.
What happened, Your Lordship?
Then
what happened, Your Lordship? We issue notice to the school managing committee. They filed the reply. Lordship kindly have in that letter, Your Lordship. That is the reply of the managing committee. Lordship, that is the reply dated 9 July 2025. So, Your Lordship, based on this, Your Lordship, so we have decided to constitute a special committee to examine all this, Your Lordship.
is he in the loop or is he a part
So
of
far, he's not in the.
You don't know anything.
No, I don't know anything what is
Still the
happening.
same village.
Madam, I am very much within the same area.
You don't know what's happening. You're keeping your eyes and ears closed.
No, my lord. I know the fact that, my lord, the inquiry has been concluded.
So far,
report has
this
been
case, Your
filed.
Lordship.
But pursuant to that report being filed, my lord, what action they have taken, we are absolutely, my lord, clueless.
So far, this case is
With a
concerned,
direction
Your
that
Lordship.
within 30 days they complete the entire thing.
No, my lord.
There's no point keeping pending.
No, my lord. We have reached this far only because, my lord, the case is pending before this honorable court. My lord may kindly see.
Lordship, so far this writ petition. So far this writ petition, Your Lordship.
Mr. N.D. Shulai today has come up with specific instructions and has produced an order dated 28 July 2025, wherein a committee has been constituted to conduct a thorough scrutiny into the affairs of the Rajabala School Managing Committee. He further submits that with the constitution of the committee, the inquiry will be conducted and recommendations, and on the recommendations, the state respondents will take appropriate action.
Lordship.
In this view, the development is expected that the inquiry be completed expeditiously within 2 weeks.
Lordship.
Expeditiously and on the recommendations, the state respondents to take appropriate action.
Lordship.
Though the prayer of the petitioner has substantially been answered, however, on the objections of Mr. S. Thapa, the matter will be kept pending until the next date. Just after 6 weeks.
That copy be served to us, my lord. At least we should be.
Then you can copies of the communication also be made over to the counsel for the petitioner.
Lordship, we'll do that, Your Lordship. Highly
6
obliged.
weeks. Yes.
Obliged.
Item number 5.
Same,
Your
madam.
Lordship. Obliged, Your Lordship.
6.
Yes, Mr. Maran.
Chief respondents are supposed to file affidavit.
Affidavit said I'll be filing during the course of, by Monday I'll be filing, Your Lordship.
But the course of Monday? What do you mean? What are you saying?
Affidavit is the signed affidavit.
Have you serve a copy?
I'll be receiving today, Your Lordship, the signed affidavit. So I'll be filing by Monday positively, Your Lordship.
Lordship, we will be filing Monday, Lordship.
Mr. H. Abraham for 1, 2, 3 and Mr. Law for
4 and 5, Your Lordship.
4 and 5.
And for number 6,
You're filing also? Not filing?
yes, on Monday we're filing.
And you for?
6.
Yes, sir. How come in 6, 4, 5 years? Submit that all the affidavits will be filed on Monday positively.
Yes, Your Lordship.
I'll leave it back.
I'll oblige, Your Lordship.
Item number 7.
Then just after 2 weeks for the joinder, any?
7.
Yes.
In this matter, I'm entering appearance for respondent number 4, Lordship.
Number?
Respondent number 4, Lordship.
Yes, Mr. Emre Marak has an appearance on behalf of number 4. Such notice complete all respondents.
Lordship.
Yes, what do you want? You want to
I'm
file
doing 2 weeks
affidavit?
time to obtain statement.
Phrase and allowed 2 weeks time to file affidavit.
Similar prayer, Your
1,
Lordship.
2, 3.
Similar prayer, Your Lordship.
Lordship,
Prayer is made by
Lordship, as per the last order, Your Lordship, respondent number 1 to 3, they have given a last chance, Your Lordship, because they are seeking times.
Those are last chance. Repeated purchases have been granted as 1 to 3. So you have to pay some cost then. You understand what this court is saying?
Yes, sir.
Because repeated purchases have been granted and still you haven't filed affidavit. So last date, in the interest of justice, we granted you for a 2 weeks time. That was on 16th of July.
Lordship, due to some
Today also you're not filing.
We'll file after 2 weeks, Your Lordship.
Because of the strike.
No, Your
What's the
Lordship.
reason?
Some difficulties, Your
You
Lordship.
file after 2 days.
After 2 weeks, Your Lordship.
No, what is the excuse for not filing before today?
Due to some difficulties, Your Lordship.
What difficulties? So can we record in the order that in the event you don't file in 2 weeks, you'll pay a cost? The orders of the court have to be honored. Yes or no? We all bound by it also. We all part of the same machinery. So the orders of the court, we have to abide by them. What to do? You give suggestion. Next date will impose cost, or you'll file it positively.
We'll file positively.
Positively, very good. Yes, so 1 to 3 submits that due to certain difficulties the article will be filed. She assures that the article will be filed positively within 2 weeks. Yes. During which you'll pay cost. Yes.
Item number 8.
May I please, Your Lordship? Your Lordship, kindly allowed me some more time to file my affidavit.
We will close the matter then.
Yes, Your Lordship, actually there's nothing left, nothing survived.
Undertaking from Mr.
Lordship is at the verge of completion, so we'll be filing, Your Lordship.
Your Lordship, if I may submit, does nothing survive?
Time, Your Lordship.
They have already conducted the religious ritual.
Granted that, but we'll take undertaking from you. That
Actually, Your Lordship, they have submitted the bill regarding that conducting of the ritual, which we have already paid to the petitioner also.
Very good.
Yes.
Somebody to $1 million or two?
From the right million. They have already made payment to them. And Your Lordship, if I may.
Completion, Your Lordship, with some
But
more
we
time.
can't bring up a new cause of action.
Yes.
Some more time, Your Lordship.
Your Lordship, if I may submit, they have already submitted one letter also regarding because there's another important ritual to be held in the month of November, the Leanyam Yodu. So if this case is still linger on, then we'll be facing a problem.
This case is no impediment.
Yes.
We just give us opportunity.
Yes, Your Lordship.
Just a week's time, Your Lordship. Just a week's time so that we can close this matter.
Though 3 weeks time was granted last occasion, today also the rejoinder affidavits are on board. However, in interest of justice, for a 2 weeks time was granted as the last opportunity.
Highly obliged, Your Lordship.
We'll close it because then nothing remains here.
Yes.
Yes.
Hearing. Item number 9.
George. Where is Nehu?
My Lord, this petition is filed by the casual workers working in Nehu. My Lord, initially they were appointed for 4 months, 6 months, 7 months like this. And 2011, Nehu has adopted a resolution and say that their appointment would be 89 days, no short break of 1 day. And they have been deprived of the daily wages. They always deduct from the wages. Because of that, they filed the writ petition. And I'll just take a Lordship, the page number.
The sound substance is that they are all casual workers.
Casual workers. Casual workers. And under the office memorandum framed by the government and followed by the Nehu, says that, my Lord, the casual workers, they are allowed to work 6 days in a week. And the Sunday, the wages will be also covered. Now, what the Nehu is saying, yes.
Now you're saying that they put an artificial break.
Yes. Now, through artificial break, they introduce that the casual worker need to work Monday to Friday, and plus Saturday they will give the wages. Sunday is excluded. Now, here 2 categories of employees are here. Casual workers are here. One set of the employees they go to work Monday to Friday. They don't go on Saturday and Sunday. But majority of the casual workers who are engaged in the essential services like driving, hostel, the electrifications, they do the work throughout, Monday to Monday. There is no break. And yet, when they receive the salary, there is always a deduction. That is the grievance. If my lord can kindly see page number 67 of the petition, my lord. Earlier, the previous system of appointment.
Page number?
Page number 67, the type copy. Now, this would regard petition number 9. They used to issue like this earlier, their appointment letter, the extension letter, madam. My lord, it says, in continuation to this department order,
Yes.
67.
The type copy
of my lord, the page number 68.
Of 68?
Well.
Okay, yes.
In continuation to this department order, even a person such, approver of the register is hereby conveyed to the extension of the terms of Shri and such, casual laborer in this university for such, minimum pay scale of rupees such, pro rata basis for a period of 3 months, with effect from such until further orders, whichever is earlier. So they used to issue this 3 months, my lord. There was no deduction that time. However, my lord, page number 71, they passed this impugned order. It says, my lord, 20th April. It says, with reference to your letter, the such pay commission dated such on the above subject, I am directed to inform you that the Vice Chancellor has given order in file number such to clear the payment of wages of casual laborers on actual days basis. My lord, is important. Basis.
So just 1 second. That means this 1/6 additional payment, it covers your Saturday, Sunday. That is your case.
Yes.
And so by this order, it took with 1/6.
Yes, it has taken away. And therefore, this the actual days basis, without 1/6 means, my lord, 1/6 means including Saturday, it comes 6 days, my lord. Additional payment for the month of such. Now, what they are trying to say is, and who is saying is that those who come for Monday to Friday, they need to get that salary only, without Saturday additional payment. Though my lord, the office memorandum says that they entitled. I'll come to that one. Now, this is the order.
Just go back to your 67 or 68 rather. 67.
My lord.
So in condition of department order number 9 says so,
yes.
Approval conveyed extension for 6.5 hours.
Yes. Working hours, my lord. Early working hours. 6.5 hours.
Yes.
For a period of 3 days. 3 months. So there is no artificial break. So they used to receive the wages throughout, my lord. Now, after this impugned order 2011, what the NEHU has done, page number, my lord, 72, the next page.
72?
Yes, when they issue extension order from time to time, it says, my lord, approval of the Vice Chancellor, NEHU is hereby conveyed to the term of re-engagement of the following casual laborers attached to the security cell on daily such, with a great pay of rupees such, 8 hours. No, 6.5 hours. Now they say 8 hours duty a day on pro rata basis for a period of 89 days. With effect from such until further orders. Now 90 days taken away. Now they introduce 89 days. In view of that, my lord, deduction they started, my lord. Subsequently, they used to issue this type of extension order from time to time to all the casual laborers. Now, they have filed the affidavit, NEHU has filed the affidavit before I go to my...
So the last part says, just see it copied, the payment of wages should be restricted only to the days on which the casual actually performed duty.
My lord.
Now, so, who issues the performance certificate?
Now the NEHU, my lord. Suppose if I go to work Monday to Thursday or Friday...
So suppose you skip one day also in midweek, you won't get paid.
But therefore, it seems it says...
You work Monday to Friday,
yes.
Suppose you don't go on Tuesday. Will you be paid wages for a Tuesday?
My lord, if it is not a holiday, if it is a holiday, it will include.
No.
But if it is absent, the deduction will
deducted.
Deduction
as per the
yes.
As per the
yes, actual days basis.
Performance certificate.
Yes. They prepare the performance certificate also. They never issued, but they maintain. Okay. Now, who has filed the affidavit?
So I understand. I mean, on actual, now they change the system from just making general to specifically only for the days that you work.
Yes.
Okay.
Yes. Now, after we filed this, my lord, they have filed the affidavit, and then who say they know there is no deduction also, and the payment of wages is on the basis of the actual days working, and they say that the impugned order we have challenged was also replaced by the authority again, and they have annexed that one. My lord, page number 8 of the affidavit filed by Nehu.
So what impunity doesn't exist anymore?
My lord, it seems but it is a modification, my lord. But it is the foundation, my lord, who actually is a subsequent consequential order they pass.
Page number?
Page number 8 of the affidavit filed by my lord senior Nehu, my lord. On 15 June.
Yeah.
My lord, may I read? Now, in pursuance to the resolution number such adopted by the Executive Council in its 146 meeting held on such, the Vice Chancellor is pleased to order that in the case of casual laborers working in a 5-day week, my lord, 5-day week, that is Monday to Friday, an additional payment of wages for 1/6 of total number of days, then if 6 my lord, including Saturday, my lord, casual laborer actually work in a month be made to them with the effect from the month of March 2011. Now, some changes happened earlier, my lord. They
I don't understand the purport of this order.
Earlier, my lord, they said only actual working days.
Earlier was 24,011.
Yes.
Correct. That was your annexure 2.
Yes.
Page 71 of your petition.
My lord.
Correct.
Yes.
Page 71.
Yes.
Yes. Now they say that this has superseded this.
My lord.
Doesn't say so.
Now it is more the earlier impugned order we challenged. They say that actual working days we entitle. So Monday to Friday we entitle. Now they introduce here, even if we come for Monday to Friday, but policy says that Saturday will be also included. So I would entitle 6 days.
Okay.
This is the modification only, my lord.
Yes.
Well,
then
now,
what else you want to show from here?
Yes. Now only now, if we go to the additional affidavit, we file through RTI to obtain the detailed documents governing the service condition of the casual laborers in the Nehu, and they have furnished a reply, my lord, in my additional affidavit, rejoinder affidavit, which we filed on 27 Feb 2024. My lord, may kindly see page number 9 of my rejoinder, RTI application.
Number 9.
Number 9. Annexure R1.
1 second. Yes.
4 information we sought. It's a 5 information. Number 1, my lord. Copy of the act or rules or OM or notification, instructions or guidelines or orders framed and issued by the competent authority, be it Government of India or UGC or Nehu as the case may be, governing the service condition of the appointment, working hours, salary, other service benefits of casual laborer on pro rata basis with effect from the inception of the university till date. They have given, my lord. Copy of the act, rules, or OM or notification, instruction or guidelines, orders framed or issued by the competent authority, be it Government of India, which is in Nehu, if any, upon which the letter, which we have impugned, madam, 24,011 was issued by the Deputy Registrar. They have given, I'll come to that, madam. Number 3 point, copy of the new ordinance or statute framed by the Executive Council or Academic Council as the case may be, concerning the service condition of the casual laborer appointed on pro rata basis since the exemption of the university. They have given, my lord. Copy of the order passed by the Vice Chancellor, So, 20 officially we sought for, they have given, my lord. And number 10 is, my lord, copy of the attendance sheets to show that they are regularly attending. Page number 10. Now, with regard to the first information, point number 1, my lord, can you see page number 13? This is the OM, formulated by the Government of India and followed by Nehu, my lord. It says, my lord, recruitment of
relevant for you,
my lord.
Which part?
My lord, relevant part would be, I mean, straight away come to 6, my lord.
The casual workers may be given 1 paid weekly off.
Yes.
After 6 years of continuous work.
Yes, my lord.
Okay.
The casual workers may be given 1 paid week off after 6 days of continuous work. So casual workers need to work Monday to Saturday, and they one day Sunday, that will also be paid. Now the second one is that the payment to the casual workers may be restricted only to the days on which they actually perform duty under the government with a pay weekly off as mentioned above. They will, however, in addition to be paid for a national holiday if it falls on a working day for the casual laborers. Now, according to me here, the OM says that they entitled the
extra day.
yes, extra. And page number 14, point number 11, my lord, NAC, if a department wants to make any departure from the above guidelines, it should obtain the prior concurrence of the Ministry of Finance and Department of Personnel and Training. All the ministries department should undertake a review of appointment of casual workers in the offices under their control on a time-bound basis, so that at the end of the prescribed period, the following targets are achieved. So, central government made it very clear that any departure should be concurred by or brought to notice of the authorities. Now, under this OM, the impugned order we challenge, even its replacement order by the NEHU, it is contrary to the OM. It is contrary to the OM. Now, when we go to page number 17, the next information they give, the basis of the impugned order, it says, in pursuant to the decision of the 62 Executive Council meeting by the resolutions of Vice Chancellor Nehu, Shillong is pleased to order revised wages of casual workers, persons on daily wages employed in Nehu, as per the instruction on review of policy and recruitment of casual workers on daily wage basis issued by the Government of India Sunset. They reform at 1918. This is the OM we have read. Well, that is the OM. The full-time casual workers.
As per the suction review policy?
Yes.
Yes. They say that in person this is 89.
89, man. The OM which we have read, page number 13.
No, this order is 89, where they follow the OM.
Well, yes.
Yes.
These are all. The minors of 1989, what they are showing.
Okay.
Number one, the full-time casual workers and person on daily wages will be paid revised wages at the rate of such 8 hours daily. No increment, no other allowances. All such part-time workers engaged on contingency basis are to be paid wages on program. The wages will be restricted only the days on which they actually perform duty. Perhaps the NEHU is lifting from them. They will, however, in addition, be paid for.
It follows OM.
Yes.
So it follows number 6.
Yes.
I mean this point number 3, correct?
Yes.
Yes. Then
national holidays, if it falls on working days, they will also be entitled for 1 day paid weekly off, subject to continuous 6 days of work in each week. So they follow the OM, my lord. Now, they will the revised wages will become enforced from such and such. Now, here. The next page, my lord, is the continuation, my lord. Now, 11, the casual laborers engage in essential services, namely water pump operators and electricians of maintenance cell, kitchen staff, hostels, case house, etc., chowkidars, security cell, drivers and bus conductor, attendants, surveyor and garbage lifter, obviously that are most utilized by the concerned controlling officer for the whole month without any day off. So they do acknowledge that they are working through.
This comes from where?
But this is the type copy, my lord.
No.
My lord, original is my lord.
See,
my lord.
You type copy second page, then where's 8?
My lord, can you see page number 18A, the next page?
No.
The type copy we are reading.
No.
Original copy is there, my lord.
No, kindly see. You must see, Mr. Sir. See the annexure, page 17. Okay. Page 17.
Yes.
It has just 1, 2, 3 Roman.
Yes.
Then 2, the letter ends.
Yes.
Correct. Then this next page is 9, 10, 11. Where does this come from?
My lord, if I may just see. My lord, may kindly see, come to page number 18A. Page number 18A. 18, my lord.
Okay.
This is a type copy.
Does not relate to 17.
Yes. But
it's not part of 17.
My lord, the page number 17 is a type copy of page number 8. Page number 8. Page number 18, my lord.
No.
This is the type copy of Nehu notes.
Nehu notes, my lord.
No. This page 17 is the type copy of 16. Correct, yes.
But
18.
Yes,
That's
sorry.
why you're confusing.
But it is the pagination.
No, that's why you're confusing the
Right.
you're saying this is
Right,
a
I'm
copy of
sorry.
18. That's
Right. It is not properly placed, madam. Probably
Your
placed.
petition of the court.
But it is a mistake from my
So the Kharas
chamber.
purposely done this previous.
Yeah, it should be placed different. But there is a inconsistencies there with regard to pagination. Sorry for that.
Yes, okay.
Lordship is correct. Page number 17 is the type copy of 16.
Yes.
My lord is correct.
Not.
Yes.
That's why when you said that page 17 is a type copy of.
Right.
Yes, okay.
No, these are the basics that they have to learn, my lord. Sorry.
Yeah, please continue.
My lord. And the type copy of page number 18 is page number 18A is page 8, my lord.
Page 18.
Page 18A is the original copy, and the type copy is the 18.
Yes.
Now this is the one they have. Nehu has given us through the RTI.
Yes.
Serial number 11 is very clear that they recognize that those who are involved in engage in the essential services, there is no holiday for them. Now, it says, however, in order to streamline the process, it is necessary that the performance certificate be prescribed in a proper format, and the number of days work should be specified in attendance register to be maintained by the controlling officer. Now, the noting, my lord. 1. My noting for pay number such was based on assumption that the principle of 7-day payment for 6 days work applies in 5 days week also. But it is very confusing for me. Since it is clear that the Government of India rules do not allow it, the same may not be applied. In view of the above, let the finance clear the bills for March on actual days basis without 16 days additional payments, since this part is against this rule.
Why do you say it's against the rule?
My lord, it is in fact not against the rule. My lord, this minute is in fact against the OM, rather, my lord. On the basis of this minute.
This maybe some. This is my noting. This is what you've typed out here, right? For paging 16, on assumption that principle of 7-day payment for 6-day work applies in 5-day week also.
In fact, that is prescribed by the OM. But rather than you say that it is against the rule.
Yeah.
And in view of that minute number 2, they adopted this one, only 5 days. On the basis of that, they issued the impugned order.
In view of this notes.
In view of this note.
In view of this, this
noting, my lord.
Made on 19/4/11.
Yes.
Okay.
On the next day, my lord, 20, they issued the impugned order.
9/4/11.
So, with great respect, my lord, this noting is contrary to the OM.
Yes.
And now regarding the attendance register, there I would show, my lord, that they are regularly.
They are still in service now also?
Oh, my lord. But they are serving, my lord. But if my lord kindly see page number 20, this is attendance register. All of them, my lord, we have an X for 2 candidates, 2 employees. My lord, for 2023, attendance sheets we have next year. Now, the last one, Mr. Kharburi, at the bottom, my lord, page number 20. This is the writ petition number 2. Now, the attendance register, my lord, for the 1 January, they have mentioned on the top 1, 2, 3, 4, date 15, my lord. And the next page, it runs till 31st.
Yes.
Now, when we see the signature at the bottom, attendance, my lord, throughout, my lord, he is engaged in essential services. He works throughout all the 30 days. And when it comes to salary, my lord, they deduct it. They treat that he doesn't entitle 30 days throughout the days. My lord, this one is also there. And for another one also, if I may place page number 44. For another candidate, another petitioner, petition number 3, page 44.
Page 44.
44, my lord. Yeah, I would highlight, my lord, the difference. Kharpuri, my lord. Kharmunai, my lord. Number 8.
1 second, just page 20.
Kharpuri is the repetition number 2. Like him, some of them are also there. And page number 44, serial number 8 is the repetition number 3. She involved in the certificate sales, not in the essential services. Page number 44. And serial number 8, P. Kharmunai.
Yes.
Yes. Here's the repetition number 3. He engaged in the certificate sales on the top they have mentioned.
Yes, Saturday, Sunday is so off.
Yes, Sunday, Saturday off. Now, even if Saturday is off, they entitled as per the OM, but they're not paying it. Now, how they deduct, my lord, I would show lastly the next year, page number 68. The extension order of Mr. Kharpuri, I would show, my lord. Now, I take the extension order 2023. Now, it says that 89 days with effect from, my lord, 14 Feb 2023 to 31st 5 2023. Now, this 14 Feb, my lord, the attendance sheet is page number 22.
Oh, fine. They're present.
My lord.
You understand it? Yes.
Now, what they do, my lord, the next page, lordship kindly see, page number 69, then I will not go to the attendance sheet anymore. Though they work, my lord. The next again extension order of Mr. Kharpuri, it says now another extension of 89 days with effect from 14/5. So another 16/5. So 2 days came. So 2 days they excluded, though he works actually. So another extension order, page number 70 would show 7 days, 5 days excluded.
Essential worker.
Yes. And in view of that, the exclusion of 2 days, 3 days, 5 days.
Two parts. One is deduction for the essential workers of 2 days.
Yes.
And other thing is deduction of those other daily wage for 1 day.
Yes.
Yes.
Right. Now I would, my lord. Therefore, I'll place a decision, my lord, to persuade my lord that the action of the Nehu is not correct. But may I place the decision, my lord. The list you have given. The list of books I have submitted, my lord, may come first. 1992, volume 2 SCC.
When did you file this petition?
My lord, we have filed this in 2023.
But the thing is that you agree with these 2011 and...
The extension order they issue. Till date they are working.
No, but you agree with the earlier notifications or orders of that time?
But it is a recurring cause of action, my humble submission. On every month, every 3 months, they are deducting, my lord, because of that, my lord. My lord, page 1992, volume 2 SSC, yes. page number 29, relevant para 6.
1992 too?
Yes, 1992, volume 2, page 29, relevant para 6. My lord, here also the Supreme Court struck down the notional 1 day break.
This is a question, 1 day break, because yours is, you're basing your prayer on that memorandum, on OM, correct? That's the thing is, you're saying that even if they are to change the policy, that it should come with the concurrence of the Ministry of Finance.
Yes.
Because it'll be beyond the memorandum, as allowed with regard to certain institutions engaging these casual laborers, where they be allowed 1/6.
Yes.
And essential services mentioned there also.
Right.
What paragraph going to read?
My lord, para 6. And I would take para 6 up para 1. I would just read out.
Yes.
The provision in clause 5, 1 day's break in service is struck down as ultra-vires. There also, my 1 day break was incorporated in the service. So, Supreme Court say it is bad. In my case also, they introduced on 89 days. Earlier 90 days. So 1 day notional break introduced. So it is bad in law. Second one, my lord.
That 89 days not to deprive you salary, it's just so that they'll have no claim to realization.
My lord, what the Nehu say that your appointment is 89 days on earlier 90 days, we pay no deduction. But in view of the 98 days now only, the notional break, you don't entitle full pay, full wages. So they start deducting on the basis of that minutes against the OM.
How does this help you?
Therefore, my lord, in the extension order they issued from time to time, they mention 89 days with the notion of 1 day break. So according to me, it is bad. But as a raw material employer. Another judgment may I place, my lord, EIR 2006, page number, my lord, 2427, my lord. Relevant para, my lord, 9 and 12. Para 9 and 12, my ethics.
Para
9 and 12, my lord.
9.
9 and 12, my lord. Yes. Madam, the respondent was appointed from time to time. Her services used to be terminated on the expiry of 89 days on a regular basis. However, it is noticed that she used to be appointed after a gap of 1 or 2 days upon completion of each term. Such an action on the part of the appellant cannot be said to be bona fide. The High Court rejected the contention raised on behalf of the appellant, herein stating, it is not possible for us to accept the aforesaid plea raised at the hands of the management on account of the fact that the factual position, which has not been disputed, reveals that the respondent workman was repeatedly engaged on 89 days basis. It is therefore clear that the intention of the management was not to engage the respondent workman for a specified period, as alleged, but was to defeat the rights available to him under such and such. Therefore, said practice at the hands of the petitioner management to employ the workmen repeatedly after a notional break clearly falls within the ambit and scope of the unfair labor practice. Number 12, my lord. However, indisputably, the respondent was appointed on the ad hoc basis. She also qualified to hold the post of such when the advertisement had been issued for filling up the seat post did not apply. Therefore, the services of the respondent was terminated as far back as such. Even if she is reinstated in her service on ad hoc basis, her services cannot be recognized in view of the recent judgment, Constitution Bench, decision Omar TV, such. Furthermore, she has absent herself for a period of 19 days from such and for a period of 11 days such. In view of that, lump sum amount was given by the Supreme Court, my lord. I want to bring home that here was exactly, my lord, notional break. Case was there. Another judgment, my lord, I will not refer to that Omar TV, my lord. Omar TV I have gone through. It has nothing to do with this notional break of 89 days. Now I come to 1986 1, 1986, volume 1, ACC, my lord, page number 637. My lord, I would take the para 2. It's a short judgment. May I read you, lordship, permission, a bit lengthy judgment. The next page, my lord. May I start reading from line, my lord, 21 from the bottom. In the middle, it is peculiar on the part of the central government.
It is?
It is peculiar on the part of the central government, my lord.
Reading page 638.
My lord, 368, my lord.
638 or 368?
68, my lord. The continuation of page number 2 will continue to page number, my lord, 638. 638.
Yes. And 20 lines down.
My lord. In the middle, it is, my lord, it is peculiar on the part of the central government. If we start 1, 2, 3, 4, 5, 6, 7, 1, 2, 3, 4, 5, 6, 7, 8,
20 lines.
20. Yes, 20 from the bottom, my lord.
Or from the bottom?
From the bottom. I'm sorry. From the bottom.
Okay, yes.
My lord. It is peculiar on the part of the central government to urge that these persons took up employment with a such, knowing fully well that they will be paid only daily wages, and therefore they cannot claim more. This argument lies ill in the mouth of the central government, for it is an all too familiar argument with the exploiting class and a welfare state committed to a socialist pattern of society cannot be permitted to advance such an argument. It must be remembered that in this country where there is so much unemployment, the choice for the majority of people is to starve or to make up employment on whatever exploitative terms are offered by the employer. The fact that these employees accepted employment with full knowledge that they will be paid only daily wages and they will not get the same salary and condition of service as other class 4 employees cannot provide an escape to the central government to avoid the mandate of equality enshrined in Article 14 of the Constitution. This article declares that there will be equality before law and equal protection of the law, and implicit in it is the further
Excuse
principle.
me, if you have anything, if you have compensation, you can take it. Whoever's your intern or something. Yes.
Well, sorry. These articles declare that there will be an equality before law and equal protection of the law, and implicit in it is the further principle that there must be equal pay for equal work of equal value. These employees who are in the service of the different Nehrus and such in the country and who are admittedly performing the same duties as class 4 must therefore get the same salary and condition of service and such. It makes no difference whether they are appointed in sanctioned posts or not. So long as they are performing the same duties, they must receive the same salary and such. Well, my humble emphasizes then, my lord, who has taken the plea in the affidavit that once they know very well the nature of the appointment, so they cannot claim. So my humble submission in my lord, Nehu cannot take that plea. That's what the Supreme Court says, my lord. And the last judgment, my lord, I would come closer to that 2023, 2013. But page number, I would take relevant page number. This is one, my lord. Para 25, my lord, 31 and 39.
31 and 39.
Yes. Yes. Here also the same issue whether my notional break of 80 days, 89 days is correct or not. That was considered.
Decisions, Mr. Chareso, on notional breakup, on this notional artificial break. Yes. Right. 20, yes. Anyway, yes. 25.
May I come to 25? My lord, 25 is the one we have just cited, my lord. I will not take further, and I would come to 31.
The 86 judgment.
Yes, 86 judgment referred to.
Yes, then 31.
31.
Yes. The petitioner filed.
The petitioner filed the muster roll for the month of March, such. According to him, such is the day on which artificial break in service was shown as per the proceedings. But the muster roll revealed that he worked on such. The petitioner has filed the attendance register for the month of such in support of the contention that except on Sunday, he worked on all other days, including days on which the days of artificial breaks break down in his service such. Now, 39, my lord. It's exactly the same, my lord, in my case. 39 is any rule, my lord, or a primary statute which virtually defeats the fundamental rights or is contrary to the principle laid down under the directive principle of state policy, or other acts that are made to fulfill the objective of the directive principle of state policy, has to be declared ultra-vile and unconstitutional. In the light of the above discussion, the action of the respondent in giving artificial break is declared as illegal, and in the light of the above referred decision of the Apex Court, the rule on the challenge is declared as illegal, unconstitutional, ultra-vile. In the light of the above discussion, the impugned order sunset is set aside, and the respondent is directed to continue with the petition in service without any artificial breaks in service till the post of research assistant is filled up on regular basis, and to pay him the minimum salary in the time scale attached to the state post. My humble submission, my lord, the action taken by the Nehu is incorrect, and the deduction is going on, my lord. We sought for particulars, pay slip, others. The transaction they do is that, my lord, Nehu used to transfer to their bank account. So they don't issue any proper pay slip, my lord. So there is a deduction. I pleaded, though the Nehu is denied. If lordship even call, if necessary, call the record of the Nehu.
Why they have deducted?
They have deducted.
For the excess amount paid?
I don't know. They entitled the salary as per the OM. But when they release the salary, they deduct. They don't give, my lord, what they entitle. Therefore, my petition, I have taken a specific plea that also. Tony who has denied.
Correct, Mr. Sen?
No, there is no deduction.
They are Oh, casual workers, I mean, to deduct from.
But
Deduction is once released, taking back.
no, no. My lord, what they have done is this, my lord. If they entitled for 90 days, the 30 days or 31 days, my lord.
Well, I understand. Now you're saying that by putting this new regime in, they deprived of the 1/6 that period should have got, correct? So that amounts to deduction from what they should get as per the OM.
Now,
if that is submission,
my lord, yes, they are not giving.
If that you factor in that, if the OM was strictly followed, that means suppose instead of getting suppose 2,000 rupees, they got only 1,800 rupees because they have not paid the extra 200 rupees, something like that.
Now, what they have done, my lord, under the OM, my submissions, they entitle 7 days, including one day week off.
That we will see whether it has 7 days or whether 1/6 will amount to 5 working days plus getting paid one extra day, 6th day.
But if that is there, my lord, my humble submission is that.
Well, again, we have to look at OM on actual.
My lord, yes. In that case, my lord, many of them who are engaged in the essential services, they are working throughout.
Essential services, different.
Yes.
If you say actuals, that means essential services. A common understanding will be that if a person is engaged in essential water, electricity, so on and so forth, other maintenance, he works 7 days a week.
Yes.
Right?
Yes.
Then he will be entitled to minimum wages of 7 days a week.
They are not paying.
Now, that is what he's saying. Yes. Now, with regard to the other casual workers, they're working only 5 days a week. Correct? Up to Friday. Yes. But then by virtue of the OM, they're given 1/6, that means an extra day, which is a paid, sort of a paid without working. Correct? Yes. So they're getting 6, what you're canvassing is 6 days for those other daily workers and full 7 days for the other essential services workers without any artificial breaks as per this, the appointment orders which have 89, which gives them a reason to, to like put in whatever, what you've impugned. Yes.
Right.
So that is the case, correct?
That is the case. That is the case. The essential services are different, my lord. They entitled, however, they are not paying, they are not receiving.
But you've stated that in the repetition, I suppose.
Oh yes, my lord, we have taken the plea. Those essential services working there also.
Different. The daily workers will be different. And as per how to apply the OM.
Nature of actual day working is different, my lord. Two types are there, my lord. However, the salary, when it comes to daily wages, even those who are working essential services, they are not even receiving. They are not receiving. There is always a deduction, and they call it this a deduction.
Okay, it amounts to deduction.
It amounts to deduction, madam.
It's not deduction. It's a non-payment.
Non-payment.
Simple. That's
yes, non-payment also. Non-payment also.
Yes.
So this is my humble submission. Lordship may kindly consider and grant the relief, madam.
Yes. Just give 5 minutes. You're ready with the reply? Yes.
May it please your lordship.
Yes.
My lord, the whole issue is, my lord, on because initially university, my lord, we have a 6 working days. Saturday was a working day. Those 89 and all, my lord. Now then we gradually, my lord, switched over to
5-day working week.
5 days working week. And with that, my lord, the changes come. Now what my learned friend has referred to your lordships, to the
let us understand that OM first.
Yes.
How, like
that OM of
whether 88. You're bound by it. That's the only thing.
We are bound by it. Now what it say, my lord, lordship, if I can take again, my lord, to clause
OM.
6 OM.
Page
13. Page 13 of there, my lord, rejoinder affidavit.
OM is not here in the writ petition.
It is in the rejoinder affidavit, my lord.
Rejoinder. Clause 6.
Yes.
The casual workers may be given 1 paid weekly off after 6 days of continuous works. So, my lord, this is reference to the establishment, my lord, where there is a 6 working day week. 6 working day week, my lord. So, obviously, my lord, in case of an establishment where there is, my lord, 5 working days, followed by, my lord, Sunday only, your lordships, not Saturday. Saturday will not be counted. Saturday is not a working day. So they are not engaged on Saturday.
Yes.
My lord, so this is the principle, my lord. So based on this principle, your lordship, now you can take my lord to my affidavit. Paragraph 6.
No, just come to 7 now, Mr. Sen. Come to 7. Now, the payment of casual workers may be restricted to the days on which they actually perform duty. Now, this will it cover essential workers? 7.
Payment to the casual workers may be restricted on the day to which they actually perform duty, government with paid weekly mentioned in 6. They will, however, be the additional paid for national holiday. My lord, this is generally all the casual workers. Generally all the casual workers. And my lord, this is a writ proceeding, my lord. Nowhere we have said, my lord, they have been engaged for 6 days and we are paying for 5 days. No, my lord, we have denied, my lord.
Only I'm saying whether from the university itself, in furtherance of this OM, whether for essential workers, they're working, okay, fine, maybe 7 days a week, you're paying them for the 6 days.
My lord, so for these writ petitioners, my lord, no. No. As per their work. As per our contention is they are working for 5 days. We pay them for 5 days.
So notwithstanding, maybe essential services doesn't matter. So they get 5 plus 1.
5 plus 1.
That's it. Yeah.
5 plus 1. As regarding, my lord, their engagement on a Saturday, my lord, we are not admitting that they were working on Saturday also.
No, that does not seem working also because the 2 days of attendance sheet, 2 days are blank. As far as Sunday. But only regard essential workers, they are working every day, Sunday included.
Now, my lord, paragraph 6 of my affidavit, that with regard to the statement made in 7 of the writ petition, the respondent states that the impugned letter dated 23/2011, providing for clearing the payment of wages of the casual worker on the basis of the actual day's work is totally justified in accordance with law. So what we are, my lord, entire payment is based on actual number of days they work, my lord, plus Sunday and national holidays. In any case, the contention said letter has no bearing in the instant case, and therefore seeking a judicial review of the said order is totally uncalled for. The impugned order dated 24/2011 have since been replaced by order dated 15/6/2011. As per the said order, in case of the casual workers working for 5 days a week, an additional payment for 1/6 of the total number of days for the casual laborer actually work in the month may be made to him with effect from March 2011. The stated earlier, the writ petitioner have been paid their wages as per their clearly spelled out in the engagement orders. Contention contrary to the above are incorrect and hence denied. Now, my lord, these we have annexed, my lord, at page 8. Page 8, my lord. This is letter order dated 15 June 2011. In pursuant to the resolution adopted by the executive on 156 meeting held on such and such, pleased to order that in case of casual labor working 5 days in a week, an additional payment of wages 1/6 of the total number of days of the casual labor actually worked in the month made to them with effect from March 2011. So this is what we are following, my lord. And regarding these writ petitioner, my lord, we are very categorical. Their engagement is for 5 days.
No, that we understand.
That is for 5 days, my lord. Now, my lord, other contention raised by my learned friend refer to some decision that are artificial break. My lord, we know, my lord, there are artificial break. That is, my lord, in case of a service, my lord, time and again the Honorable Supreme Court has said, these are the artificial break, these are to be ignored. Now, these comes, my lord, more pertinent, my lord, more relevant when regularization and other thing comes.
No, that is good.
But that, my lord, after Umar my lord, those are gone, except, of course, one ad hoc cannot be replaced by another ad hoc. They are treated to be fairly, my lord, so that artificial break should, what my learned friend has referred to, that 2013. That was in that context. Some temporary arrangement has been made, even that temporary employee, my lord, breaks were shown. Then this is very unjustified. You don't show artificial break till regular incumbent comes back.
Yes.
So, my lord, those principles will not apply here. So, our whole contention, my lord, I will not, my lord, take the other paragraph. All the paragraph, my lord, we have seen strictly as per, my lord, actually the work rendered by them. Now,
what about essential services then?
My lord, so far these writ petitioners, my lord,
won't cover that.
So far these writ petitioners, my lord, as per the instruction I drafted the affidavit, my lord, no. They are never engaged, my lord, on a Saturday. They are never engaged in Saturday.
Why did they sign the attendance sheet?
My lord,
you see the attendance sheet annexed to the writ petition or to the rejoinder. Where was annexed? The thing is, it shows that Mr. Kharpuri, what essential service does he do?
They are just citing an isolated case of one Kharpuri, my lord, and then they are seeking relief for entire, I think, my lord, there are 22 writ petitioners. 21 writ petitioners, just citing. Now, my lord, is where, my lord, the writ court, my lord, there are certain limitations, my lord. When this kind of situation, my lord, disputed question of facts, my lord, just relying on this one signature, my lord, of one Kharpuri, your lordship.
We just.
No, my lord, I understand.
I think it's just
I know what
as to whether, you see,
exactly.
The only thing is that whether these workers or casual workers or whatever are being denied in any manner as per the policy adopted as per the relevant OMs.
Exactly.
That's the only thing. There should not be any exploitation.
Exactly.
They are small people. And if they're rendering the service, they should be paid. That's only.
Yes, my lord. That's all. So our contention that we cannot, my lord. If we are admitting that on Saturday they are engaged, my lord, we cannot say that we will not pay you on Saturday.
Exactly.
That's how can you say, my lord? We cannot say that. We are not admitting, my lord, anyway. Specifically, we are they are working for 5 days. They are getting 5 days plus one Sunday, and plus national holidays. This is their entitlement, my lord, as per the OM, as per the work order issued to them. Nothing more than that. Now, what my learned friend, my lord, one isolated case. And some signatures, my lord. So, my lord, that I think will be too much based on this thing, your lordship, holding them, they were essential workers engaged on a Saturday, my lord.
Can the university re-examine specifically, these cases of the essential workers, set apart from the other casual workers? I don't think if the work week is 5 days, then they'll get a 5+1. And if the work 6 days, will be 6+1. But essential workers, they should be given an added incentive if they work 7 days a week, because you
obviously, definitely, your lordship, definitely. That too, as a lawyer, also, my lord, I will not refute that. My lord. If they are working, they should get. But the instruction I have received, my lord, of course, based on their records and whatever it been produced, they are not engaged or they are working on a Saturday. They are not. So even if your lordship send it back to the university, my lord, I do not know, my lord, what purpose it will serve. So only way out, my lord, if he has a genuine case, if all the 22 he can show, then these are the, my lord, performance register, these are the register.
The court have noted earlier on that performance register issued by whether, because you keep a performance register, correct? So if that attendance sheet can't be relied upon, this is the official attendance sheet, correct?
Yep, yes.
The one referred in the rejoinder.
Yes.
Yes, it's official, correct?
Yes.
But of course, my lord, I'm not in a position, my lord, to, my lord.
Can you kindly get just short instructions as whether this is accepted one, because it's signed by it's countersigned by junior engineer also. So at least for these people who are working on the basis of the OM itself, they should not be denied if the workings the extra day.
No, but if the court asks, my lord, the university is under obligation to.
No, I mean just to whether we can't rely on these. That is your submission.
No, I'm not saying that. What I say, if your lordship asks the university, my lord, to verify.
Where is your law officer?
She's not here.
She can produce the record also. In para 5 of 6 of my writ petition, we have taken specifically 9 of them are in essential services. Nehu is not denying the affidavit. 9? 9 of them. Out of 21 are in the essential service. Nehu is not denying in the affidavit. Madam, I see para 5, 6 of my writ petition.
In the course of hearing, the attendance register, which has been annexed to the rejoinder affidavit of the petitioners, has been perused by this court, and instructions and a query has been raised as to whether this is a reliable piece of document to be taken into consideration while deciding the matter. So, Mr. S.N. praised that we allowed 1 week's time to obtain specific instructions as whether this is one section and to verify from records as to whether the same is. We don't know, it might add a signature later on after getting it. Anyway,
if, my lord, they can produce the salary. Those who are working essential also, they are not receiving.
Let me
got instruction. If this thing is that, yes, we will see. Because that's only the tentative. We will see one part of your prayer will not be. If it's a 5-day working week, it will be, as per OM was 1 plus 1 day.
Yes,
that is fine.
Yes.
But if essential services they're working 7 days a week, they're already getting. There'll be 6 plus. It'll be like normal for them. The 6 plus 1 again.
Yes.
But only thing they'll be working on the 7th day always.
That is the entire issue right there.
No, that is very clear, and that partial break has no relevance in this matter.
No relevance. Not a regular issue.
Yes, call me.
Obligation.
Issue number 10.
Yes.
Please, Your Lordship. There's a very limited issue in this writ petition. Limited issue. Well, it's the petitioner before Your Lordship's case, before I open up the matter, is that he is otherwise eligible for promotion. He meets the criteria. Now, his grievance is that DPC is not being held by the department. In spite of recommendations and it being otherwise due, there is no DPC being held, so he is stagnating as against a post. For that limited relief, we are here before Your Lordships.
Are there vacant promotional posts available?
Yes,
He's working as what?
He was originally appointed as an assistant, research assistant. Subsequently, regularized as a research associate and presently posted as a senior analyst. The promotional post would be that of Senior Geometrical Officer.
Senior
Geometric Officer.
What's a geometric officer?
Something I am.
Which department? Which?
This is again from NECTA, which my lords had earlier been pleased to dispose of, which was carried in appeal, and my lord's order has been upheld.
Geometric.
It would be something regarding some scientific post. You don't have another copy of this? Take it.
Where's the recommendation?
I'll take Your Lordship.
Dr. Mozika, you ready with the matter?
Page 94, is the recommendation.
Some time.
I thought as much. 94.
This is from the Director General, my lords.
Okay.
It's 94.
Why not holding DPCs then? Because they say that recruitment process should be initiated for vacant posts of
in the counter affidavit that's been filed, my lords, the respondents have taken a plea that maybe my initial appointment was irregular and not illegal. They say it's irregular.
Okay.
That we dispute, my lords, but even be that as it may, if a DPC is held, my lords, because I am serving there is no questions raised about my lords being in service as senior analyst. DPC will consider that at an appropriate level.
But Dr. Modi, I see this letter since 2022.
But this is by
the recruitment process means what? Recruitment process doesn't mean that everybody who's serving it is only those in the zone of consideration, correct? They'll be considered in the DPC. And if you feel that he's not qualified, then that has to be spelled out. So you'll know how to tackle the situation.
If I may also draw your lordship's kind attention to page 80.
Yes.
My lords may kindly see, in compliance of the so-and-so, has initiated the process of recruitment against vacant posts. In this regard, recruitment rules for the various posts in Nectar entirely prescribed to be filled out by vacant posts by promotion, failing which by deputation, failing which by direct recruitment. On review of the vacant post, it is observed that for the post of senior geomatics officer, an officer already working in Nectar as senior analyst fulfills the criteria for consideration. It should be consideration of his promotion to the post of senior geomatics officer, subject to the findings of the DPC. Well, it's as per RR, DPC selection committee shall consist of 3 members, DG Nectar as chairman, and 2 other members not below the level of scientist. D. Director will be nominated by the chairman, governing council of Nectar. In view of the above, chairman so-and-so Nectar is kindly requested to nominate 2 members for DPC selection committee to initiate the process for filling up the post and to proceed further. This is way back in 22 minutes.
What does Nectar really do?
Well, it's a scientific organization. Well, it's a
Northeastern Center for Technology Application.
What does it do? Name can be anything.
Geomapping. Well, as they do geomapping and
no, not geomapping. They're into extension of scientific technology, agriculture and horticulture and other things.
Well, so what I'm instructed is for agricultural purposes also they do some geomapping and other things are there.
You have no idea otherwise.
Honestly, no, it's.
Krishna has some idea of it.
Yes?
Well, I'm instructed that this is what they do. Well, it's
interesting, because what is Nectar? Now it's coming in the court once, twice, thrice. And this is Dr. M. Mohanty's head AI division.
I'm sorry, Milits.
See the signatory.
Milits.
Is sent to, addressed to head
AI division. I don't know, Milits, whether it would be artificial intelligence or something else, maybe.
What to do this?
I pray them take out next week. I'll have instruction. I can convene a DPC.
Because if that means this letter, you say, Mr. Paul, means you that you're the senior, you're the only senior, you're the only person eligible, senior analyst.
Mallet. I am eligible with the Mallet.
You're the only senior analyst working.
Well, that we'll have to seek instructions because there is a criteria of experience as well, Millet. There's a number of years.
You read just now on review the vacant posts.
Page 80, Millet.
It's not singular, it's plural. It's observed that for the post of senior geomatics officer, an officer already working in Nectar as senior analyst fulfills the criteria to become a promotion. Who's this person?
This is a petitioner before your lordships, Millets. Because it says, Millets, the RR say by promotion, deputation, if not, then by direct recruitment.
No, I'm saying he's the only senior analyst working in this geomatics.
Well, we'll have to seek instructions on that. We are not aware.
You find out what your client, what kind of nature of work he does, what kind of organization is working under.
Well, it's.
Otherwise.
We'll Millets assist your lordships with that, Millets, the relevant information.
Dr. M. Mozika plays some combination to be able to obtain instructions as to whether any development is there pursuant to the letters. Pursuant to the communication dated, last communication is 28/11/2022.
22 Millets.
For initiating a recruitment process against the vacant post of senior
geomatics officer
GOMATSES officer in Nectar, NECTAR. Just after 1 week, yes. Where can be disposed of?
Well, because there's a very limited prayer, my lords.
No, he has a legitimate expectation. If he's the only person, the senior analyst there.
13.
Obliged.
13, 14, applying some accommodation. The service matter also.
Yes, sir?
Service matter.
Service matter, Lordship.
Very rare you get Mr. Depp to come and appear for this court. Correct? He's more comfortable more forward, sir.
Suddenly appears on it. Difficult to come.
You inform Dr. Muzika before he suddenly appear next date. Okay. As a DSG appears from accommodation. List is matter after 2 weeks. Yes.
14.
14.
Same. 15.
Obliged.
My lord, we just informed that the conduct of the council is not well today, and even the leading council is outside of station, so we can pray to 2 weeks now.
Who's on station?
The leading council. LSA.
No objections. Yes, as is reported that the High Council is not available. This is posts matter on
2 weeks now.
Post matter for 2 weeks.
17.
Yes, Mr. Nyota, ready?
Yes, sir.
Very good. Yes.
Here, Your Lordship, the respondent number 2, Your Lordship, had issued an advertisement, Your Lordship, which is in page 19, Your Lordship. Page 19.
19.
There are 6 posts, Your Lordship, in this advertisement for assistant public prosecutor. 5 posts were for reserve category, and 1 post is for unreserved category, Your Lordship. And in this
5 posts
for reserve category.
Record advertisement. They are dated 12 October 23. 12 October 23.
Yes, Your Lordship.
12 23. Then
there are 6 number of posts. 5.
Okay. This is assistant public prosecutor 6, unreserved 1, EG 3, Caro 2. Okay. 6 posts, right?
Yes. Then along with the condition, Your Lordship, and criteria, which was in page 19, Your Lordship. The qualification is that, Your Lordship, that point number 1 is degree in law from recognized.
1 second. Then next page?
Page 19, Your Lordship.
Okay.
Para 2, condition of
law from university, preferably with not less than 3 years of experience and practice in prosecution of criminal cases in courts.
Yes, and number 2 is candidate with record of successful prosecution in criminal cases in court will be preferable, Your Lordship.
Okay.
So here, Your Lordship, the petitioner having met the qualification had applied for the same, Your Lordship, and being found suitable, he was called for a screening test, and after that, thereafter, he was called for personal interview. So he has a.
He's on unreserved category.
Yes, he applied for only that unreserved category for that 1 post, Your Lordship. Then, Your Lordship, after personal interview, Your Lordship, he has high expectation that considering his experience, Your Lordship, he will get. But then
practice how many years?
He joined in about in 2013, Your Lordship.
He joined in 13, so
Yes.
he has okay.
Yes.
This is 23. Okay, yes. 13 he joined.
2013, Your
He has 10 years experience.
Yes, yes.
Okay. Petitioner 10 years experience. Okay.
Then the respondent has issued a notification, Your Lordship, which is in page 22, Your Lordship, annexure 9.
20. You are Ahmaduddin Laskar?
No, Your Lordship. The petitioner was not named in the successful category, Your Lordship.
Yes. Result interview. So absent public prosecutor. So.
Yes.
Yes.
Then after the petitioner came to learn, Your Lordship, that the respondent number 3, Your Lordship, which is here number 1, Your Lordship.
So you only agree with this
unreserved category, Your Lordship. The rest we are not touching, Your Lordship. We only agree with this unreserved category.
Okay, yes.
So the petitioner learning after that he learned that this respondent number 3, Your Lordship, has not fulfilled the criteria laid down in
Why
the
is he not qualified?
because he has just obtained his LLB degree in 2023, Your Lordship. And
obtained 23.
Yes. And also, Your Lordship, he has not clear out the AIB examination, which is enable him to practice as a lawyer, Your Lordship. So that is my grievance, Your Lordship.
No, where you made a statement that you know positively that he passed in 23, does that have any experience in prosecution of criminal cases?
Yes. In my pleading, Your Lordship, in page 12, Your Lordship.
Page 12?
Page 8, para number 12.
Okay.
That however, the petitioner did try to know the reason of his failure, and he learned that the respondent number 3 had obtained LLB degree only in the year 2023 and have not even cleared his All India Bar examination, which will entitle him to practice as a lawyer, and only after clearing the said exam he could be obtained the certificate of practice from the Bar Council of India, and as such the question of experience and practice in criminal cases does not arise, Your Lordship. And Your Lordship, in recent judgment of Supreme Court, Your Lordship, is fine
that means that he applied in unreserved category only.
Yes, Your Lordship.
Or he was just a topper and he was put in unreserved category on merit.
I mean, talking about the petitioner here, Your Lordship.
No, the respondent number 3.
That I have no idea, Your Lordship, whether he applied for that unreserved or.
This exam conducted by MPSC.
Yes.
Yes.
In recent judgment, Your Lordship, which was passed by the Supreme Court, Your Lordship, it says it's fine that the law graduate appointed straight away from college, Your Lordship.
That is for judicial post.
But here also has similar 3 years experience is
No, 3 years experience. No, this is given assessment. All applicants should have 3 years experience.
Yes.
Yes.
And even in this
MPSC filed affidavit.
Well, it's we filed. I appear on behalf of respondent number 2.
That's the only ground.
Yes, I'm agree with that only because the respondent
qualified
because he has not fulfilled as per the advertisement.
This is only that. Yes.
The observation of this, which is in page 42, Your Lordship.
Yes, paragraph 57-58. Yes.
That is my only grievance, Your Lordship, because.
Yes, let's see MPSC first.
Well, this is the issue which has been pointed out by my learned friend. If I may take your lordships back to the advertisement.
Back to the advertisement?
Yeah, let's. Lords would find that at page 18.
18, yes.
Yes, my lords. This is where, my lords, all this. Well, it's if my lords have this 2.1.1.
Yes.
For the post of Assistant Public Prosecutor in the Office of the Directorate of Prosecution Meghalaya, degree in law from a recognized university. Now there is a word inserted here, preferably with not less than 3 years experience. So my lords, the essential qualification is a degree in law.
Yes.
An additional qualification, if any, my lords, would be experience of 3 years. And then, my lords, the second part says candidates with records of successful prosecution of criminal cases in court would be preferable. Now, the admitted position is, my lords, and that we put in affidavit is that the private respondent has secured the highest marks in the written examinations as well as in the personal interview. It's not disputed. They do not dispute this fact. Which is why, my lords, in the considered opinion of the MPSC, it was decided, my lords, that the in our recommendation, my lords, the private respondent's name was recommended, because we say, my lords, that the qualification of 3 years experience is not an essential qualification, it's an additional qualification. Essential qualification would only have been a master's degree in law. I'm sorry, my lords, a degree in law. That is what the stance of MPSC is before, my lords. And my lords, what we've stated here in our counter affidavit, if I might just take your lordships, please. Paragraph 5 and paragraph 7, my lords.
That is number 2, right?
No. It's filed on, I'll just give the exact date. It's filed by one Ashish M. Sangma, Malaj.
Ashish M. Sangma, yes.
Malaj have it on 4th of April.
Paragraph
4, Malaj, we've reproduced the qualification. And paragraph 7, Malaj, this stands unrefuted, where we say that he's got the highest marks in the written examination as well as the personal interview, thereby securing first position. My lords have para 7.
Yeah. Yes.
Valid. That in essence is the challenge, Malaj. The other challenge, of course, of this category, that may not be applicable in this case. Malaj. So Malaj,
how much is the writ petition score?
Malaj, I'll just give the figures. I think we have.
That's on record.
It's not on record.
On your records, I mean, with your records.
We'll have the records. My lords may just bear. I'm a little handicapped, Malaj, because. This is here. This is the roll number. I'm sorry, Malaj, that record is not available with us. If you
see, the thing is like this. When the absence is preferable means what? It means when, suppose 2 candidates have more or less same,
more or less the same, then Malaj's preference would have been given to
same, they have scored more or less the same marks, whatever. And so at that point of time
then preferable will come in.
Preferable clause will be
put into application.
Not that
it is, Malaj, it is not the case of the petitioner, Malaj, that he has secured more marks or equivalent marks to the private respondent.
If that's not the case, then
the question of preferable does not come in, Malaj, because then that additional qualification will only come in, as your lordships have rightly pointed out.
Equal.
Malaj. If they were, Malaj, on the same footing, they had probably scored even close by, Malaj, then the preferable would have then come in.
Experience.
Malaj. Because that again would have to be read in conjunction with subclause 2.
Where's the appointment order? It's been appointed, it's number 3.
That appointment order is not under challenge.
No, have you annexed any affidavit?
No, we have only recommended.
Number 3, number 3. Where's the affidavit?
Sorry?
Petition last page.
The writ petition, my lords, last page. This is the declaration of
the recommendation. You've been appointed?
Yes, sir. Yes, your lordship, I've been appointed, your lordship.
You started working?
Yes, your lordship.
How many cases are you handling now?
Right now, we're not assigned cases. We're still under training, your lordship. I'd also like to submit that I missed a day of training just to come here, your lordship.
Why did you come then?
Your lordship.
You're appearing in person?
Yes, sir, I'm appearing. Yes, your lordship, I'm appearing in person.
My friend chooses to defend himself, Malaj.
You'll go and get better experience than that. Yes.
If my lords so desire, Malaj, I can place the records.
Just place
I'll place the original
close the matter. Yes.
I'll place
Mr. Nyota, if they see the records, if that's the only thing. Suppose you're equal, or on all other things remaining equal, then preferable cause will come in. Otherwise, doesn't mean that preferable means even though you scored less than the other candidate, but because you have, that doesn't mean that. Only if they say a law degree from a recognized university with 3 years experience, then it becomes like mandatory that a person who applies, like what will happen now to the new judicial service exams, is that, which there will be recruitment soon. So we'll have to insert that because of the Supreme Court judgment, that, it'll have to be not preferable with 3 years experience, but with 3 years experience.
Yes. Preferable, Malaj, then creates the difficulty.
Creates a problem.
But the petitioner was conscious of this, Malaj, when he applied. The other aspect is always, Malaj, that having, Malaj, not being successful, he is there before my lords.
Of course, I don't have a ground. Just produce records of next week.
Next week, we'll produce the original records.
Mr. K. Paul Leonard Counsel for the Public Service Commission, respondent number
2,
to produce records on the next date. Post on soon, sir.
That's
all right.
Item 20.
Please, Your Lordship, my lord, I'm very sorry. On last occasion, my lord, I made a submission. Perhaps I could not place it properly. As a lawyer, I feel, my lord, perhaps there can be a mediation, because they want, even the government says they want to sort it out. Now the question, my lord, the consent of the client is required. Now here, my lord, I just talked to the university. One thing, my lord, this is a property matter, my lord. This kind of decision come from the EC, whether they will go for mediation. I told them, of course, as a lawyer, I say it's not
mediation. We can refer any time, doesn't matter.
And other thing is this, my lord, they are already on informal engagement with the officials. So what I will pray at this stage, my lord, lordship grant some time, my lord. Let them engage, my lord, officially.
May it please your lordship. Lordship, because we need this complex, this building, lordship, to start the campus for the Captain William.
It depends how you negotiate with them.
Lordship, we are kindly allowed us to take possession of that building.
How can the court allow that?
Lordship will pay them compensation. We will engage the PWD as well as the Deputy Commissioner, Lordship, to assess the compensation. Lordship, we'll pay them, Lordship.
No, fair end is different.
We need Lordship, we need this complex.
The questions about whether they are agreeable. See, they agree with what is that you treated this like your own property, without consulting them. That's the only thing.
No, Your Lordship, they were very much present, Your Lordship, during the meeting, Your Lordship. They were.
Let them engage, Your Lordship, whatever is time. They can take up what my learned friend is saying.
Let record, yes.
They can take it up
Though
with
this
the
matter had been, though it had been observed earlier that the instant matter would more effectively be settled through mediation. Mr. S. Sen today, Learned Counsel for the Petitioner University, has submitted that the decision has to come from the meeting of the Executive Council, which is yet to be convened on this matter. Stop. He praised that he further submits that as there has been overtures from the state respondents with regard to settlement, the matter be posted after some time to enable some resolution.
They can engage in the meantime.
The next paragraph, Ms. Andy Shulai, however, has submitted that though
we are in need, Your Lordship.
There are talks going on with the university authorities. The government is in dire need of the premises, in as much as what you see,
Lordship, to start the campus of the Captain William.
To start the campus of the
Captain Williamson Sangma State University, Your Lordship.
Captain Williamson Sangma State University, which has just been established.
Lordship.
Stop. He in this context, he praised that orders be passed that the process of any be completed as early as possible.
Lordship, if Lordship will just
to cooperate in the proceedings.
Lordship, allow us to take over, then we'll assess the compensation, Your Lordship.
He has also made a prayer that directions be issued to allow the state
Lordship
to occupy premises on payment of fair rent to be assessed by the
The compensation, Your Lordship, we'll take over. We'll pay them.
We buy the whole property,
Lordship. That is what the instructions say.
So that's yes. Anyway, that's acquisition, right? You want to acquire by the State Act.
Lordship, we pay them compensation, Your Lordship.
No, stop. In view of these submissions and considering the urgent requirement of the state respondents for the purposes of the newly established university. It is directed that the parties sit down immediately to try and resolve the issue, preferably within a period of
1 month,
4 weeks from today. Yes, at least after 4 weeks.
Apply, Your Lordship.
How big the complex? Very big.
I have not.
Where is that complex?
It's not used by NEHU anymore.
No. Summer, when I have set out the details. What are in the occupation of the university?
Some under occupation by the state, Your Lordship. But we need the whole building, Your Lordship. Apply.